Okay, pleased to see you again in the second session. In this class, we will have a taste of a tort law in United States. One of very basic course, I suppose, to acquaint yourself with the American legal system. Let us get projection retrieved. I made some preparation in coverage about topic. Intentional torts, harm to economic and dignitary interest, negligence, liability without fault, product liability, and nuisance, and general considerations for all tort cases. So the basic structure in instruction would be available generally in this line of consideration. Points of consideration have been presented. Actually, tort law is they possess the very attribute often characterizing the common law legal system. So the areas of its traditional that will be explained in terms of case laws. Generally, the statute or public code will be less in other area, perhaps administrative law, and contract law is also one other source. But UCC would be a great avenue, of whom the traditional common law series, especially in terms of commercial transactions. So tort law would very reflexive when we think about the common law system, and I also may remind of a Professor Bohemian comment, very interesting in the last international symposium. His topic is a cultural defense involving criminal law cases. Of course, torts and criminal law are distinct areas, although we may find some exciting area. For example, punitive damage is one kind of a remains that could evoke the fears of mixed feelings between crimes and torts. So punitive damages would actually in excessive compass generally viewed inadequate when we think about contract damages or others. So due compensation to recover the loss or damage is perhaps one important crucial ideal that is pursued in the justice of contract law or torts. That concept could be generally modified, or in some sense altered, that the punitive damages could be avoided in the aspect of sanction. The punitive damages is considered to possess the criminal element that could be questioned in some cases by domestic constitutional scholars or international jurists who engage in the work of approval or what kind of endorsement of foreign judgment. They would assess its legitimacy, whether it could possess the quality to be enforced in the domestic jurisdiction. Punitive damages will incur excessive amount of damages on part of a tortfeasors, which is incompatible with general ideas and system of tort law in Republic of Korea, for example. So the court may order to diminish the amount in due extent to come in comfort with our national public policy. The kind of laws would be taught in your class in this department. In any case, we could have a separate genre between criminal and tort law, and the what a tenet or theory or framework would be made distinct. Nonetheless, it could share some elements to deal with the kind of activities often perceived as harm against other parties. So Professor Bohanian commented, perhaps would be a joke to generalize his presentation in the international symposium. So, what is cultural defense? So consider, for example, the tort law of the United States will find as different from Korean law, defamation. In United States, defamation is not absolute defense. Absolute defense. Nonetheless, defamation, the law of defamation of Republic of Korea find a different principles, partially, of course, could be vast in common elements, but the truth is not absolute defense in the Republic of Korea. So he could enjoy a preserve of immunities from defamation in the United States, and he also is protected by Korean law when he is staying in Korea as a professor of law lecturer. So very advantageous personally between two major legal cultures. So that is cultural defense. How is it ironic in our general sensibility? So I realized that is a point of cultural difference. The very theme that he intended to deliver in the international symposium, and tort law are distinct area to have many potentials between legal traditions, especially in purview of different cultures and compassions. Sorry, somebody interrupted to visit my office. Actually, I ordered a short dinner, a Chinese voodoo, and in my plan, I have to report to the night class today, so I have tests. In any case, a toss is very fantastic to cross the different legal traditions and systems, and nonetheless we still can entertain some sharings. For example, importantly, the product liability, and the theory is considered to reflect the kind of bargaining powers in the modern capitalist society. Often the producers will consider more powerful and may impose their prestige or advantages status about the bargaining process. And so many injustices could actually be present between producers and consumers. So we have a strong need as a matter of public policy to restore a balance in justice between two actors and parties. Product liability would come in that spirit, that the consumers could prove the case more easily. For example, burden of proof may shift in some extreme cases, and in other cases many traditional rules have been modified to support side of consumers. So tort theory could be restructured partially involving the scheme of product liability, and often many modern nations would incorporate the theory into the civil law tradition. So we have, for example, independent statute beyond the general civil code, and also you will learn the special insurance policy to cover product liability. And now the documented credits could be transacted involving the insurance certificate on product liability, and the insurance contracts could be disputed, where, for example, whether when the liability of insurer would arise, what point of time. If actual damage would occur, then it could suffice the claims for insurance liability, or if if the actual litigation could be brought to dispute the insurance relationships and insurance contract. That is the point of time that the insurance liability could be invoked. The kind of question, actual damages ordered by court has to be a prerequisite to claim insurance money wise. Many views or opinions will be exchanged involving legal theory. The kind of concern would be shared in other classes, and also basically have some dimensions between intentional torts and negligence, and in some cases we will explore the strict liability, and the liability without the fault is required depending on the torts and our activities, and it is the legal elements pertaining to that series. So we consider, for example, the concept of prima facie case, very interesting, and the plaintiff should establish a prima facie case of intentional tort to claim his damages. The plaintiff must prove act by defendant. Often the act means a volitional movement by defendant, and also some mental element, what we call intent. Intent may be either specific, general. Specific means the goal in acting is to bring about specific consequences. And general means the actor knows with substantial certainty that these consequences will result. And you will have a point of consideration of transferred intent, and the concept also is applied to criminal law case. And recall on your lesson transferred intent, the murder or killing, homicide, killing of others would be condemned, but what about a transferred intent? In some cases, the shooter with intent to kill one person, specific person, may miss his target, or actually the trajectory would be messed into other person, or the kind of a situation would bring the consideration of transferred intent. The transferred intent doctrine applies with the defendant intends to commit a tort against one person, but instead commits a different tort against that person. It commits the same tort as intended, but against a different person, or commits a different tort against a different person. In such cases, the intent to commit a certain tort against one person is transferred to the tort actually committed, or to the person actually injured, for purposes of establishing a prima facie case. We will learn limitations on use of transferred intent. Transferred intent may be invoked only where both the tort intended and the tort results are one of the following. In other cases, we generally negate the application of a transferred intent. Assault, battery, forced imprisonment, trespass to land, trespass to trespass. And you will see very basic tort claims in coverage. Let us illustrate some of them. Battery, assault, and forced imprisonment, intentional infliction of emotional distress, extreme and outrageous conduct. And you will see elements that should be proven as a prima facie case. For example, what is forced imprisonment? Elements of prima facie case would be an act or omission on the part of defendant that confines or restrains the plaintiff and to a bounded area. And the actor should possess an intent, of course, and causation is required, which will not differ from other legal systems. Often causation brings some important point about reasonableness. So foreseeability doctrine could be embroiled as applied to other cases, and also be relevant with contract law others. And what is a causation to be identified as element in this case? Sufficient measures of confinement or restraint, insufficient measures of confinement or restraint, and time of confinement, awareness of confinement, what is a bounded area. Insufficient acts of restraint include moral pressure and future stress. Could operate to actually imprison some victims, falsely, of course. Sufficient acts of restraint include physical barriers, physical force, threats of force, failure to release, and invalid use of legal authority. So in some cases, insufficient methods of confinement would deny a prima facie case. So you will need to exercise your standard between sufficient methods and insufficient methods, whether it is justified to constitute a false imprisonment, what else. And let's take an example. International infliction of emotional distress. Elements of prima facie case would be an act by a defendant amounting to extreme and outrageous conduct. And the culpability in this case would require intent or recklessness. And also causation is required. And damages would be incurred if severe emotional distress has actually resulted in this case. What is extreme and outrageous conduct? This is conduct that transcends all bounds of decency. Conduct that is not normally outrageous may become so if it is continuous in nature. It is directed toward a certain type of plaintiff. Imagine if the scope of persons would be vulnerable, especially in the context of extremity, or what is outrageous conduct, to be weighed with the specificity of human groups. We will consider, for example, children, and elderly persons, a pregnant woman, super sensitive adults, if the sensitivities are known to a defendant. It is committed by a certain type of defendant. Common carriers or innkeepers may be liable even for or mere gross insults. A prima facie case requires a requisite intent. Unlike for other intentional torts, recklessness as to the effect of defendant's conduct will satisfy the intent requirement. Actual damages are required. So nominal damages would often be viewed to be insufficient in establishing a prima facie case. Proof of physical injury is not required. The more outrageous the conduct, the less proof of damages is required. And consider some interesting case involving a bystander. When the defendant intentionally causes physical harm to a third person and the plaintiff suffers severe emotional distress because of it, the plaintiff may recover by showing either the prima facie case elements of emotional distress, or that she was present when the injury occurred, she is a close relative of the injured first person, and the defendant knew facts, the element stated in item 1 and 2nd. And we also are exciting to consider intentional torts to property. Consider the types of intentional torts generalized through the tort courses: trespass to land, actually trespass to chapters. Also, recall your learning on conversion and seriousness of interference. And we will meet typical defenses to intentional torts. Consent is very elementary, as you expect. plaintiff consent to defendant conduct is defense, but the majority view is that one cannot consent to a criminal act. Any consent fact pattern raises two inquiries. Was there valid consent? For example, Freud may intervene to negate the consent defense. The fraudulent inducement into some loss or damage by tortfeasor should still be condemned as a matter of torture. You will agree. And the defendant stay within the boundaries of consent. So, for example, he or she would not use a gun in a boxing match. And the consent should be expressed. In some cases, implied consent is considered favorably to constitute defense. Defendant is not liable if plaintiff express consents to defendant's conduct. Exceptions will be in summary. Print out. Mistake will undo express consent if defendant knew of and took advantage of the mistake. And consent induced by fraud will be invalidated if it goes to an essential matter but not a collateral matter. So we also appreciate the differences between materiality of fraud. And consent obtained by jurist will be invalidated unless the jurist is only a threat of future action or future economic deprivation. Consider an implied consent. Apparent consent is the which a reasonable person would infer from custom and uses of plaintiff's conduct. Normal context, inherent in body context pose, ordinary incidental contact, etc. Consent implied by law arises where action is necessary to save a person's life or some other important interest in person or property. So please exercise your power of imagination. For example, firefighters would often get in emergency to carry their duty into extreme conditional circumstances. So if the law requires a normal context of interaction, it will fail to meet the challenges of situation, and importantly, paralyze the responsibility and discretion of firefighters. In that case, consent may be implied by law, and also in some cases, the capacity matters to determine the defense could be sustained or not. Individuals without capacity are deemed incapable of consent, incompetence, drunken persons, and very young children. In some cases, consent may be viewed as exceeding. If defendant exceeds the scope of consent and does something substantially different, he may be liable. And what are other sources of traditional defenses to intentional torts? You will perhaps recall self-defense, or defense of others, or defense of property. And you also may be brought into necessity. And necessity is one other paradigmatic of one element that operates through many areas of law. When a question involves the defense of self, others, or property, ask the following three questions. Is the privilege available? The tort must now be or about to be committed. Already committed torts do not qualify. Is the mistake permissible as to whether the tort being defended against is actually being committed? Was the proper amount of force used? So excessive amount of force would also modify the true operation of self-defense. In some cases, it could be a mitigating factor in assessing damages, or in criminal law theory would mitigate the penalties, punishment, actually in the kind of a legal requirement, and the total circumstances would be appreciated in actually determining the proper sentence is criminal proceedings. In some cases, it is prescribed in 1A of a structural requirement, which impose a legal duty to mandate the modification into a sentence or others. So you will perhaps be brought into previous case, which was highly provocative of Korean public. Actually, the case is a theft. Actually, a kind of burglary when we apply the concept of common law of criminal provision. The perpetrator is a trespasser at night time into the dwellings of victims, and the burglar is actually frightened to see the very resolute response, reaction from the householder, who is a housemaid in the case, and he actually picked up the kind of arms, or a sword, or kind of a bat to pursue him, who actually run away from the crime place. So the crime scene actually ceased in that stage. Nonetheless, he still pursued through the public street and applied one excessive force, and actually commit a battery with a bat on his hand, which caused the death to the burglar. So how do you assess this situation? Very excessive, and the reaction could not be justified in normal sensibility. That the victim actually surrendered himself and ran away. So he will get better to call the police to catch him or others. We have been very excited to talk about that. What actually mishap, what kind of cruel consequence of death, although he was a burglar. Okay, thank you. I still am bad about my cold. Thank you for your attention, and we'll see in the next class. I have to report.